interpreted. There are 4 specific items that this board is being asked to.
Those were the 4 that I was thinking of. Is that the consensus? Okay. Is there any other specific direction that you want to give to us?
Okay. Shall we simply go one member to the other, starting from left to right, or would that
You need to
put too many people on
specific direction?
Yeah. Mm-hmm.
If you have someone, I think you were the only one that had additional direction for Mr. Tussey. Or were you saying that you did? Yeah, that's all.
Yes, I already gave direction. I'm ready to amplify on what I said before.
I don't think that we need to do that actually now, because we're going to make these separate, 4 separate resolutions.
I would love a little clarification, because I've certainly heard 4 board members whose opinions I find fairly clear, and 2 of them lean one way and 2 of them lean the other way. That leaves 2 board members, and me in a place where I need a little more guidance.
Okay. We could just ask board members to speak up. Any order you like. I will start unless, just to clarify how I feel about these issues. I think we certainly do have jurisdiction to, and this is the proper place to hear this appeal. With regard to height, I do believe that the comprehensive plan and sustainability plan and their use encouragement of LEED standards through this incentive of additional height is something that should be allowed in any, even in this case, since this is the one we're talking about. With regard to density, there is a more, in my opinion, more modern standard that we're using for determining density. I think that the ODP is, in my opinion, just silent on density in this area, in the section H. The architectural standard, I think I was pretty clear about that already. I think that having never been a committee convened, it's a high expectation that there would be one. Too high an expectation of the applicant. So I begin. We want to go down the line, or Johan, you'd like to go next?
I can, and jurisdiction, I have nothing to add to my previous comments. Height and standards, I would say the more recent action of City Council would control, and that would be our present ordinance as interpreted by Mr. Parker on page 2 of his first letter, which was item 10. The residential density is contested between the parties in any event, but there again, the most recent statement of the legislative body, which is City Council, should control as opposed to the contested OPD. Architectural review I've already covered, and it being a familiar aspect, as Mr. Parker has also pointed out, that no committee is there to really assume that, and hasn't been, if it ever has been. I also concur with Mr. Parker's letter of June 19th. Excuse me, that's not correct. Wait, I've lost the letter. With Mr. Parker's letter of May 31st, and while there may be some arguability about sections of our statute on 17.365A. I believe the more reasonable construction is the one that he has applied, and therefore I would vote to uphold that also.
I'll go next, and oh my gosh, this was tough. Like, I'm not really liking the high amount of density is not really my call to make. I can't use my subjectivity, whether I like it or not, I have to be objective. And I've just vacillated back and forth, so. But here's what I've arrived at. So as far as jurisdiction goes, yes, indeed, we have the jurisdiction. As far as the density goes, even though I would hope that some more negotiation could take place between the developer and the neighbors, I am going to say that I believe that 3.6.5A takes precedent, and that indeed Mr. Parker was correct on his decision, which would also apply to the height. I appreciated the discussion about when that came about, the LED coming in 98, I think I heard, and of course the ODP was 82, and so the most recent one takes precedent, in my opinion, and so I would uphold Mr. Parker's decision on that, and would also say that the architectural review, as we know, is not applicable, not used in the city, so therefore I would say no on that.
Okay, with regard to jurisdiction here, I agree with previous comments that we indeed have that jurisdiction. With regard to the lead height and density issues, I feel that the operative language is a conflicting provision resolution, because the two positions on these two facets of the development, height and density, have created a conflict. And I think in the event of a conflict, the zoning ordinance is very clear at 17.1.6.2A that more restrictive provisions apply. So I feel that the terms of the ODP would apply to height and density. As far as architectural review committee goes, while it's been clearly stated that no committee currently exists, that to me does not preclude a committee being formed unless the ODP was amended to remove the committee. I've seen cases in other situations where older laws that have not been essentially active and applied have still been considered valid. The age of the law is not usually a determining factor. So I think that in the event that a plan is produced, as Mr. Silvestro stated, a committee would be convened to opine on that plan. So I see that language is still operative. So that's where I come out with this. Thank you.
Thank you. Sure. Regard to jurisdiction, as I stated earlier, I think we do. For density and height, for me, my interpretation of 365A of the ordinance is pretty clear. I think through the legislative body, 2012 rezoning, I think, in my opinion, the planning director appropriately interpreted the provision of the ordinance. So I would vote to uphold the decision or interpretation for density and height. With regard to the architectural review committee, I don't think that the applicant could be held to that provision from the ODP since it doesn't exist. It wouldn't be reasonable to think that they could fulfill that obligation.
Thank you.
So on the matter of the jurisdiction, thank you for reading the charter and reminding us that that's what we're here for. And I do believe we have jurisdiction. I don't think it's in dispute or shouldn't be. Regarding the height, the lead height and the density, I believe that 365A is valid in cases where there is no conflict, that there's a choice. But I believe that 17162A, the conflicting provision, supersedes that because it's very clear. Any regulation imposed by any provision conflicts with any other requirement, the more restrictive. And I think that's pretty clear. Regarding the architectural review, I agree. I don't believe it can be required because there's not a committee in place. It doesn't exist. So, thank you.
Thank you. Mr. Tuthill, do you have enough direction?
I believe I do, Mr. Chairman. I plan, given what I've heard here, to prepare several different resolutions that will address the topics so that the members will have the opportunity to vote next week. Obviously, your insight tonight is not final, it's not a vote. You do have to act by resolution. I think I've got enough guidance to do that. I will prepare a draft and send it to you, Mr. Chairman, over the next few days. Unless there's additional discussion tonight, what you need to do is move to continue this hearing for resolution only. You won't be taking additional public testimony. You're certainly welcome to have an open discussion, change your mind, or feel differently. But if we could get a motion to continue this hearing until 7 p.m. on the 22nd of January in this room, I will have some draft resolutions, which once I get them drafted, I assume I can give to the secretary with your permission, Mr. Chairman.
Yes.
And they can be made available to the public in advance of the hearing, as well as the members of the board.
Good, thank you. And I would say that what you heard is not the two members of this board voting. We are expressing opinions to help Mr. Tuthill write resolutions. None of us are bound by what we have said here when it comes to actually voting on a resolution. And we are still under the rules of a quasi-judicial meeting, and that means that we can't talk about any of this with each other or with any of you outside of this hearing or the continued hearing. And so if anyone had any question about whether there was any independent minds on the Board of Adjustments, hopefully they've been answered here. I appreciate everyone's time and patience and the testimony of everyone. And I think we grilled everyone sufficiently. And we will, I will entertain a motion to continue the meeting until, I think I can actually make the motion. I can make the motion to continue this meeting until January 22nd at 7 p.m. when we will act on the resolutions that are presented.
A second.
So we will vote all. Vote. There we go. That's okay. So unanimous vote. Thank you to everyone.
Thank you.